The Minnesota Government Data Practices Act regulates how cities manage government data. This presentation serves as a resource for staff and local government agencies to navigate the management of human resource and employment-related data. The Minnesota Government Data Practices Act, which is Chapter 13 of Minnesota Statutes, is a state law that controls how government data is collected, created, stored, maintained, used, and disseminated. Data practice laws attempt to balance the public's right to know what their government is doing, individuals' right to privacy in government data created and maintained about them, and the government's need to function responsibly and efficiently. The Minnesota Government Data Practices Act regulates the management of all government data that are created, collected, received, or released by a government entity, no matter what form the data is in or how the data is stored or used. Briefly, the Act regulates what data can be collected, who may see or get copies of the data, the classification of specific types of government data, the duties of government personnel in administering the Act, procedures for access to the data, procedures for classifying data as not public, civil penalties for violations of the Act, and the charging of fees for copies of government data. As you see here, government data is either data on individuals or not on individuals. Data on individuals are classified as either public, private, or confidential. Data not on individuals are classified as public, non-public, or protected non-public. The classification system outlined in the chart here determines how government data should be handled. Note that most human resource data is considered data on individuals. This presentation will focus on that classification. Also note that the meaning of each of the three definitions, based on how the government data is classified, is the same. So government data is divided into four types. Data on individuals, which is classified as either public, private, or confidential. Data not on individuals, which is classified as either public, non-public, or protected non-public. Statistical or summary data that's derived from data on individuals, in which individuals are not identified, and data on descendants. Unlike any other form of local government data, human resource data is private, with exceptions that make specific data public. All human resource data is private, except with respect to current and former employees, volunteers, commissioners, and contractors. The following information is public: name, employee identification number that cannot be the Social Security number of that individual, gross actual salary, salary range, terms and conditions of the employment relationship, contract fees, actual gross pension, the value and nature of employer-paid fringe benefits, as well as the basis for and the amount of any added compensation, including expense reimbursement in addition to salary, job title and bargaining unit, job description, education and training background, previous work experience, date of first and last date of employment, the existence and status of any complaints or charges against the employee, regardless of whether the complaint or charge resulted in disciplinary action, and the final disposition and any disciplinary action taken against the employee, together with the specific reasons for the action and any data documenting the basis for the action, excluding data that would identify city or agency employees who were confidential sources, as well as the complete terms of any settlement agreement, including buyout agreements, except that the agreement must include specific reasons for the agreement if it involves a payment of more than $10,000 of public money. Best practice would suggest working with your local government attorney on these settlement agreements. Work location and telephone number, badge number, work-related continuing education, honors and rewards received, payroll, timesheets, or other comparable data that are only used to account for an employee's work time for payroll purposes, excluding any timesheet data that would reveal the employee's reasons for the use of sick or other medical leave or any other not public data. With respect to current and former applicants for employment, the following information is public: veteran status, relevant test scores, rank on an eligible list, job history, education training, and work availability. Note that the names of applicants are private data until they're placed on the eligible list. eligible for appointment to fill a vacancy. All other information not listed above is private data, available only to the data source. Agency employees with a need to know the information based on job responsibilities are authorized to see the data. A Tennessen warning outlines those rights communicated to an individual asked to supply private or confidential data concerning him or herself. A Tennessen warning clearly articulates the rights of subjects of data. In Tennessen warnings, statements must be included that inform the individual why the data is being collected from the individual and how the entity plans to use the data, whether the individual can refuse or is legally required to provide the data, any consequences to the individual for supplying or refusing to supply the data, and the identity of the persons or entities authorized to receive the data. Anyone may exercise the right to access public government data by making a data request. A data request must be made to the responsible authority or the appropriate designee. The responsible authority will ensure that established procedures are followed to comply with requests for government data in an appropriate and prompt manner. Upon request to the responsible authority, an individual shall be informed whether they're the subject of the data and whether the data is classified as public, private, or confidential. The responsible authority will then provide access to private or public data upon request. An individual may contest the accuracy, current status, or completeness of public or private data. The responsible authority must respond within 30 days, either correct the data or notify the individual that the responsible authority believes the data to be correct. When a data request is denied, the responsible authority must inform the requester in writing. The response must cite the statute, temporary classification, or federal law which the determination is based. The responsible authority or designee must provide copies of public data upon request. If the requester wants copies, included data transmitted electronically, he or she may be required to pay the actual costs of searching for and retrieving government data, including the cost of employee time and for making, certifying, compiling, copying, or electronically transmitting the data. An individual may not be charged for costs related to separating public from non-public data. For copies in excess of 100 pages of letter or legal-sized black and white documents, actual charges may be required if they exceed the per-page charge. When a person requests access for the purpose of inspection, the responsible authority may not impose a charge or otherwise require payment of a fee to inspect data. And finally, the Minnesota Department of Administration's Information Policy Analysis Division, or IPAD, is responsible for ensuring advisory opinions on questions related to data practices. While not legally binding, it's important to seek competent legal advice if your agency makes decisions contrary to an IPAD opinion.